Can a spouse sell property without the permission of the other spouse in Illinois? In Illinois, questions about property rights in marriage often arise, particularly around whether a spouse can sell property without the other's consent. This topic is crucial for couples who own assets jointly or who are navigating potential real estate decisions amid relationship complexities. Legal standards and requirements under Illinois law, property ownership rights are significant in determining what a spouse can or cannot do with marital assets. The law distinguishes between marital property, which is jointly owned by both spouses, and non-marital property, which is owned individually by one spouse. The Illinois Marriage and Dissolution of Marriage Act governs how property is classified and managed within a marriage. If a piece of real estate is considered marital property, both spouses typically have a say in its sale or transfer. This rule ensures that neither party can unilaterally make decisions that could negatively affect the financial interests of the other. An attorney can guide couples on how joint ownership structures work, highlighting that any property held as tenants by the entirety requires both parties' consent for transactions involving the property. When a spouse can sell property without consent, there are specific scenarios where one spouse may be able to sell property without the explicit permission of the other. Non-marital property. If the property was acquired before the marriage or through inheritance, it is considered non-marital. The spouse who owns such property has the legal right to sell it without seeking consent. Pre-existing agreements. A prenuptial or postnuptial agreement that outlines asset management could provide a spouse with the right to handle specific property transactions alone. Consulting a lawyer to review these agreements is essential to understand their implications fully. Understanding the process in Illinois, the process for selling property typically involves legal documentation that reflects ownership. For jointly owned properties or those considered marital, both spouses are required to sign deeds or related sale agreements. This ensures compliance with state laws and prevents disputes over unauthorized transactions. For non-marital properties, the owner can proceed with the sale independently. However, it is wise to involve an attorney to verify the property's classification and any legal nuances that may affect the sale process. This can safeguard against future claims from the other spouse. Protecting your interests whether considering a property sale or facing a potential unauthorized transaction, understanding your legal rights is crucial. A law firm's support can help ensure all necessary permissions and legal protections are in place. For tailored guidance, Law Office of Russell D. Knight is available to assist. To discuss your case, call us at 773-334-6311 and visit our office at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, United States.